Good afternoon and welcome to the first episode of the Kantor Kantor podcast. For 30 years, our law firm has focused on all things health insurance related, from long-term disability, long-term care, to life insurance, whether those policies were purchased through your employer or privately. Can you start by explaining what ERISA is and how it applies to long-term disability?
ERISA is a federal law that was passed about 50 years ago, and its original intent was to protect pension plans, because originally pension plans often invested their entire funds into the stock of the company that started the plan. So in one particular case, there was a car manufacturer called Studebaker that went bankrupt. Its stock became worthless, and the pension plan became worthless. So in 1974, Congress enacted a law to make sure that pension plans were safely and prudently invested. So if the company went bankrupt, the pension plan stayed solvent. Over the next 10, 15 years, the courts expanded their interpretation of ERISA such that it covered any employer-provided benefit, which included health insurance, life insurance, even long-term care insurance. So if you were provided one of those benefits by your employer and your employer was a private entity and you were denied a benefit, your remedies had to be through the mechanisms afforded by ERISA, which are in many ways very limited.
I see. And what are some of the more common misconceptions about ERISA and how they apply to long-term disability claims? Well,
first you have to understand that all 50 states deal with insurance matters differently. So people in their own states think this is just an insurance claim and their state's laws. For example, California has very strong consumer protection laws for insureds, and they provide very significant remedies for what we would call a bad faith denial. You can get emotional distress damages and sometimes even punitive damages. And people who get their coverage where it's governed by ERISA think when their claim is denied, they should have a right to seek those damages. Unfortunately, the federal law and the Supreme Court of the United States has made very clear those remedies are not available. Also, under ERISA, people watch lawyers on television and they see jury trials. They think that's what their ERISA case would be like if it ends up in court. It's not the case. ERISA does not provide a right to a jury trial. It doesn't even provide a right for the insured to be in court when the case is decided. These cases are decided by a judge based on basically the medical records and other records which either support or fail to support the claim for benefits, whether they be life benefits, disability, or health.
So talk us through the process, take the audience through the process of filing an ERISA claim. What are some of the key steps involved?
Well, there's different processes for different claims. Let's talk about disability. If you have a disability policy through your employer and you have some kind of illness or injury that prevents you from performing the material duties of your own occupation in the way they're usually performed, and you have to leave work, it's a relatively simple process to start. Your employer will have provided you with information about, if it's an insured plan, who to submit your insurance claim to. There's three aspects of it. One is the insured statement, where they're asking you basic questions about your age and things like that. And then more specifically, what are your job duties and what is your physical condition that prevents you from performing your job duties? There's also a set of forms to be filled out by your doctor, because absent a doctor's agreement, it's almost impossible to get a claim approved. Your doctor has to substantiate an injury or illness that would support an inability to perform one's occupation. Lastly, there'll be forms for the employer to fill out, which is basically when did the insurance become effective, because there are issues about pre-existing conditions, how much was the insured making, and when do they stop working.
So we touched on this a bit, but as long as we're talking about disability benefits specifically, what types of disability benefits are covered under ERISA, and how do they differ from certain disability benefits not covered by ERISA?
Well, people often confuse workers' compensation benefits with long-term or short-term disability benefits. Workers' compensation benefits are intended to provide you with monies for your inability to work for a work-related injury. Short-term and long-term disability are there to provide you for loss of income benefits, no matter the source of the disabling condition. There's also Social Security disability, which is a federal program that people pay into that will provide you with a limited benefit if it appears that you will be unable to work in any occupation for more than 12 months. Social Security disability is a relatively difficult benefit to obtain, and it's becoming more and more difficult with the federal government's deficit. They're making it harder to get these benefits.
So discuss the role that insurance companies play in the denial of long-term disability claims, and how can claimants navigate any potential conflicts of interest?
With the exception of very, very large employers, Verizon, maybe United Airlines, just huge employers do not fund disability benefits themselves. What they do is they buy from an insurance company, be it MetLife, Prudential, Hartford, Unum are all examples. They'll purchase from one of these companies what's called a group long-term disability plan or a short-term disability plan. And the insurance company insures the company's employees and promises to pay a percentage of their salary if they meet certain conditions. Now, you're asking about conflict. The insurance company is receiving premiums, which they're happy to do. But when they're asked to pay a claim, they are literally taking money out of their assets to send to an insured. So while legally they are obligated to act as a fiduciary and look at all possible reasons to pay a claim, in my experience, they often look at all possible reasons not to pay a claim. So the insured who's making the claim or the employee who's making the claim has to do everything within their power to make it that the insurance company doesn't really have a viable option but to pay it. Examples are providing a full description of one's job duties. If you have a job that requires a high level of cognitive functioning, and there's something wrong with you cognitively, whether it's due to something like chronic fatigue, long-haul COVID, MS, and you can't think the way you used to, and you can't perform your job because of your inability to function cognitively, that's a disability. If you're a truck driver who has to spend 8 hours a day driving a truck, but you have a significant back problem where you can't sit, those are disabilities. So you have to explain to the insurance company both what your job duties entail and what it is about your medical condition that prevents you from doing them. And then you have to hope that your doctor's records back it up. Your employer will frequently provide the insurance company with your job description, but you want to make sure the insurance company knows exactly what your job description is. Often the employer's description is generic, and you want to fill in the gaps so they know exactly what it is that you do.
Another great transition, as long as we're talking about things that could potentially trip up a claim, what specific deadlines or timelines does a claimant need to be aware of under ERISA when filing a long-term disability policy?
Well, that's a very complicated question that could take a very long time to answer. First, the insured should make the claim as quickly as they possibly can once they leave work. They don't even, policies like this have what are called elimination periods. A long-term claim may not start for 90 days, 180 days, or sometimes even a year after you leave work, but you don't have to wait until that time period is up in order to start the claim process. It's always good to start early. If the claim is denied, however, the law mandates that you be given 180 days to submit an appeal of the denial. And the law has been twisted, in my view, from requiring the insurance companies to give you the right to appeal. And now they say that if you don't appeal, you can't pursue your case in court. So that 180-day period is critical. It can be extended with the insurance company's agreement, but you have to have that in writing. This is a somewhat complicated legal issue, but sometimes people leave work, they're terminated because they're not doing their job, and they learn sometimes years later that they've got a serious medical condition which was preventing them from doing their job, and they didn't even know it. I've had a number of cases involving MS where people are terminated because they're too tired to work, they're cognitively impaired by the multiple sclerosis, and they're terminated because they're not doing their job. And the person maybe doesn't even disagree. They know they're not doing their job, they just don't know why. And maybe a year or two later, they're diagnosed with multiple sclerosis. There are states which will allow you to go back and make that claim years later. Some states do, because they have what is known as an insurance doctrine called notice prejudice. Other states don't have it. So you'd have to look to the laws of your particular state. Because while ERISA governs all states, there's something in ERISA called the savings clause, which saves from ERISA preemption certain state insurance laws. It's something that an insured without a lawyer is never going to understand. If this situation arises, they'd need to talk to an expert in the field of ERISA.
So what are the more common reasons that long-term disability claims are denied, and what steps can claimants take to prevent this from happening?
Well, as I said before, the most common reason that a truly valid claim is denied, and I want to stress that we often see claims that we don't even think are valid, but for a valid claim to be denied, the most important reason is that an insurance company has the money and they want to keep it, and they will create a reason to deny it. But typically, the reasoning they will give is that the person's medical records do not support impairment to the level that the insurance company believes would impact their ability to perform their job. There are other reasons. For example, if you become insured on January 1st and you've had multiple sclerosis the last 10 years and you've been treated for it, and you become disabled, let's call it July 1st, most of these policies have what's called a pre-existing condition, where if you go out from work due to a pre-existing disability and you've only worked for 6 months, they won't pay. That's typically a valid reason for denial, but it also generates a great deal of litigation, because somebody might be fatigued, see their doctor and saying, I'm very tired, and the doctor might say, get more sleep and maybe exercise. And then 6 months later, while they're working, they go back to the doctor who diagnoses them with multiple sclerosis. The insurance company will say, you were treated or diagnosed for that condition before you started working, we're not paying. But seeing a doctor for fatigue without a diagnosis from our perspective would not allow them to deny the claim. So that's a situation where the insurance company would give a reason, but we would think it's not a valid reason. Also, the insurance companies employ doctors on a full-time basis, and from our perspective, they're employing them to find reasons to deny claims. Your treating doctor, or an insured treating doctor, is not there to support your long-term disability claim. He's there to treat you. And when they're treating, they're not focusing on putting precise words into their medical records, which will support a disability claim. And insurance companies are known to take words out of context, to twist them, to use the words in records that would support, whether validly or invalidly, a denial. A good example, doctors will often use the term stable in their records. Somebody who has progressive lupus and they're getting progressively worse, but maybe over a 6-month period, this person who is very ill, who cannot work, the doctor may say their condition is stable. But stable doesn't mean not present, and it doesn't mean they can work. It just means it hasn't deteriorated since the doctor last saw them. The doctor may not write down all the symptoms from one visit to the next. And the insurance companies will often utilize the lack of information in medical records to justify denial. Insurance companies will often use their doctors to call up an insurance treating physician and have an over-the-phone conversation that's not recorded, and the insurance company doctors are known to cherry pick. Well, do you think it's possible that your patient could work maybe 30 hours a week? And the doctor may say, well, anything's possible. And what's written down in the record by the insurance company doctor is, treating doctor says it's quite possible the insured could go back to work. It's not supposed to be an adversarial system. The insurance company is supposed to be on your side, looking out for your interests. Unfortunately, that rarely happens. Now, I will say that there are hundreds of thousands of disability claims submitted every year. And, people don't walk into my office and say, I made a claim, my claim was paid, will you sue them? I see the denials. My colleagues see the denials. So I can't paint every insurance company as being evil, but we do see examples of horrendous claims handling and horrendous denials that we believe from the bottom of our hearts that if it wasn't for the protections afforded the insurance companies by ERISA, they would never deny these claims.
Are there any recent changes to ERISA that claimants should be aware of?
Well, ERISA has not really been changed since its original enactment in 1974. However, when it was enacted, Congress directed the Department of Labor to initiate and promulgate regulations on the handling of ERISA claims. And over the past 50 years, the Department of Labor has promulgated, I think it's 3 or 4 different sets of regulations. Every time, the regulations are more and more specific about what are the obligations of an insurance company, because the lawyers like myself have banded together and made sure the Department of Labor understood the things that insurance companies were doing to deny claims and to allow themselves to deny claims. For example, I discussed the fact that you have to appeal. The insurance companies would accept the appeal, send the materials to their doctors. Their doctors would say, well, I disagree with this information in the appeal, and that would be the last word. The last change of the regulations, which was in, I believe, 2018, the regulations stated the insured gets the last word. If the insurance company doctor says, this is what I disagree about, the insured is entitled to take that information, show it to their doctor, show it to a vocational specialist, show it to anybody they want to, and counter it. An example would be an airline pilot. And the insurance company doctor says, well, yes, I understand that this doctor has a mild case of glaucoma, but it can be corrected with glasses. And that could have been the last word. But now that airline pilot could say, but the FAA says I am not legally allowed to fly commercially with even a mild case of glaucoma. and that should be submitted so the insurance company considers it. Having the last word is a very powerful weapon, and people need to know that they can use it.
Can you discuss the importance of working with an experienced ERISA attorney such as yourself as opposed to potentially handling a claim or an appeal on your own?
Our firm offers anybody who asks for it a free 30-minute consultation. And people who are making disability claims often call and say they want to retain us to assist them in making their claim. And we listen, and we often say, you don't need to retain us. There's no reason to. You've got what sounds like a pretty clear-cut case. Just make your claim. On our website, there's information about what they should do. And we tell them, you don't need to waste your money hiring us at this stage. Now, if the claim is denied, things change dramatically. As we've talked about before, there are very precise deadlines. If they're missed, the insured is done. There's nothing further they can do. Also, ERISA provides that only the information given to an insurance company after the first denial, but as part of the appeal process I spoke about, will ever be looked at by a court if it ends up in court. So if a claim is denied, it's probably important that an insured at least seek the advice of an ERISA attorney. The ERISA attorney may say, look, all they said to you was they need more forms filled out by your doctor. Just do that and you'll get the claim paid. They may say your claim is deficient for a variety of reasons, and we may say, yeah, we think you should hire us so we can help assist you in getting your claim paid. So every case is different, but there are many, many traps for the unwary that the insured handling their case by themselves after a denial would step into that trap where an experienced ERISA attorney would not.
Are there any specific strategies or tips, information you can provide for the individual who decides to deal with this claim on their own, a long-term disability claim governed by ERISA?
Sure. Be prompt, be diligent, and it sounds like simple advice, but it's not always easy for somebody who is too ill to work to make sure all these forms are submitted. It may require hounding your doctor a little bit and getting your own forms in. The other thing that I would advise is be honest, because insurance companies love to pounce on information that they can say was not honestly transmitted. For example, somebody may have a very, very bad back, and the question is, are you still driving? If the answer honestly is, I drive a limited time, I may go to 7-Eleven to pick up milk for my kids, I may pick up my kids from school, but I do my best not to drive. That's the answer you want to give them, not I never drive. Because if they see you driving and they can question your credibility on one answer, they'll question it on everything. Insurance companies do cost-benefit analysis. If somebody was making, I'm going to say, $30,000 a year, and the benefit the insurance company would have to pay is less than $2,000 a month, they're not going to do a great deal of investigation to find a way to deny the claim. But if somebody's earning $20,000 a month and the insurance company has to pay $12,000, they may spend a lot of money to see if they can find a way to deny a claim. And one of their favorite tactics is to conduct surveillance. So if you say, I don't walk without a cane, I don't drive, I don't exercise at all, and then they conduct surveillance and they see you taking a walk, even if your doctor has said, try and walk, if they conduct surveillance and you said, I don't walk, and they see you doing it, they're going to question your credibility. If you say, I don't drive, but they see you driving, they're going to question your credibility. So you want to be not only honest, but you also want to make sure that your answers are not too expansive. One of my favorite James Bond movies was Never Say Never Again. And in filling out their forms, you don't want to say never. You say rarely. or as little as possible for things like driving, so that if they do conduct surveillance and they see you doing something, you can say, I told you I do it rarely. You happen to catch me on that rare day.
What are the potential outcomes of a long-term disability claim, and what are some of the factors that can influence success?
The vast majority of employer-provided long-term disability policies have a test change for your occupation after 2 years. What that means is during the first 2 years of your disability, they will pay you if you're unable to perform your own occupation. After 2 years, they will typically only continue to pay benefits if you're unable to perform any occupation for which you are qualified by training, education, experience. So let's take the airline pilot I spoke about before with a mild case of glaucoma. The insurance company may say, yep, we get it. You can't be an airline pilot. We'll pay you for 2 years. But with your mild case of glaucoma, you've got experience as a pilot. You could be a trainer on the ground. You could do other work for the airline. So after 2 years, we expect you to try and go back to work. And that is a reasonable position. On the other hand, we could take a school teacher who has multiple sclerosis for a private school, because the public school teachers are not governed by ERISA, but a school teacher for a private school who has MS. She has good days, she has bad days, and the insurance company will say, okay, we get it. You're going to miss 8 days of school a month. No school is going to allow you to do that because it's too disruptive for the students. We'll pay you. At the end of the 2 years, they may say, well, you could do, and that's where it gets interesting. You could do what? With the same symptoms, the same limitations, it's unlikely the insurance company is going to find any employer who is going to employ this individual who may miss 8 days of work because of fatigue, because of pain, because of cognitive impairment. So in some situations, the own occupation, any occupation test change will have little meaning. But I will tell you that insurance companies always look, and they are always looking for positions that they think people can fill with their limitations.
Here's a fun question. Could you share a real-life case study from your practice, of course, that illustrates the effective representation of an ERISA lawyer in a long-term disability case?
One of my favorites, I think I spoke about before. I had a man come to me, actually came with his brother, who was a physician. They had not seen each other for several years. The client had worked successfully at a company for 15 years with exemplary job performance reviews every year. And then the reviews became not so exemplary, and after a couple of years, he was terminated. His brother had not seen him. About 2 years later, his brother flew out from the East Coast just to see his brother and see what was going on. And he got off the airplane, walked in the terminal, saw his brother and said, "Oh my God, what's wrong with you?" He got him to a doctor, and they determined that he had multiple sclerosis. He was impacted cognitively. He was extraordinarily fatigued. He was having trouble walking, and he couldn't work. They submitted a belated claim for benefits to the insurance company, and the insurance company said, "You're too late. We don't have to deal with this." And I wrote a letter to the insurance company, explained them California law, which says you need to show prejudice. We have doctor's records that go back a ways, and we got the doctors say there's no question this man with a high degree of medical certainty had symptoms of MS when he was terminated, and that the doctor was sure the termination was due to his impairing symptoms. And that's where the case stopped, because someone at MetLife looked at it and said, "You're right," and they paid the claim. I think by that point it was 3 or 4 years retroactive, and that man is still receiving benefits today. I've handled thousands of claims. If I sat and thought about it, I could probably come up with dozens of outrageous denials, that I was able to get rectified. I can also come up with situations where it was very close, where it was a gray area, where we were able to convince a judge that we were right, more right than the insurance company was, that the preponderance of the evidence showed that the insured was entitled to benefits. And that's an interesting topic for lawyers, which is the preponderance of the evidence. When ERISA was enacted, it didn't include instructions for the courts to determine when a claim was payable and when it wasn't. And in 1988, the Supreme Court came up with a rationale that these claims should be looked at de novo, which meant the court should just look at the medical evidence and decide who was right and who was wrong. And unless, and this was just a bizarre thing, the Supreme Court said, unless the plan established by the employer gives the decision maker discretion. If the decision maker, which includes insurance companies, are given discretion, then the court will not look to see who's right or wrong. They'll just look to see if the denial was totally unreasonable. So this was a classic case of the fox being given the keys to the hen house. The insurance company is holding the money, and the court is then going to let them say, we don't think this is payable, and the court would approve that denial as long as there was some reasonable basis. Since that happened, plaintiffs' lawyers like myself fought in the state legislatures. We've been unsuccessful in Congress, but we've been able to convince 25 state legislatures to ban those clauses. They're called discretionary clauses issued in their states. So, for example, if a policy is issued to a California employer or insures California employees, discretion is prohibited. So the courts look at the claims de novo. Who is more right and who is more wrong? In the other 25 states, the state legislatures have been unwilling to ban those provisions, and people in those states have a very uphill battle in convincing courts that not only was the denial wrong, but it was unreasonably wrong.
So what resources or organizations can individuals turn to for information supporting when dealing with an ERISA claim or a long-term disability claim in California?
I would not limit it to California. I think just about every major illness has a support organization that can give them guidance or point them in the direction of an experienced ERISA lawyer, whether it be the MS Society, the Lupus Society, the Parkinson's Society, the Alzheimer's Society, the American Cancer Society. There's even now long COVID groups that are assisting people in how to make disability claims. There's probably not a back injury society, but the internet is a wonderful thing in some ways, that it will point you to resources that can help you submit and support your claim. The internet, as I said, can be a wonderful tool. It's not always a wonderful tool because you have to be careful that the information you're getting on the internet is accurate. Which is why if you're going to hire an ERISA lawyer, you need to vet that ERISA lawyer. I could again expound on this for hours. If you're going to hire an ERISA lawyer, there is one thing you need to look at that is more important than any other, and that is that the ERISA lawyer you hire has a track record of taking cases to trial and winning. Because if the ERISA lawyer is known as a settling lawyer who never tries cases, the insurance companies know that, and when they go to settle a case, will pay them far less than they'll pay the lawyer who they know if they don't pay enough, will take the case to trial. Now, I want to be clear about this. We may handle 200 lawsuits a year for ERISA disability claimants, and we might try 5 of them. That's 2.5%. maybe we'll try 10 of them, 5%. So I'm not saying that you have to look for a lawyer that's trying every case, because they don't exist, because most cases will settle because either they're a slam dunk for the insurance company and they're going to pay very little, they're a slam dunk for the plaintiff and the insurance company is going to fix it and reinstate the benefits, or they're gray and both sides have to compromise. But there's times when the insurance company believes they're right and my client believes they're right and I support it, and we end up in trial. But we're not afraid to go there. We have dozens and dozens of published decisions over the last 20 years to back up what I'm talking about. And the insurance companies know it. They know that if they have the weak case and they don't offer a reasonable amount to settle, we will take it to trial. And that point, when we win, they'll pay the insured every dime they're owed, and they'll pay a substantial amount in attorney's fees. ERISA does provide that if you have to litigate a claim to get it paid, the litigation is successful, that the insured is entitled to make a motion to have at least a significant portion of their attorney's fees paid. In the Ninth Circuit, which encompasses California, Arizona, Washington, Oregon, and Montana, it's almost a guarantee that you're going to be awarded attorney's fees. Other circuits are not quite as favorable, but they will typically award some level of attorney's fees. So if you're looking for an ERISA lawyer, you don't just plug in ERISA lawyer to Google and get the first name you find and call that lawyer. You need to look at several different lawyers, and you need to ask any lawyer you're speaking to, can you give me a list of your trial victories over the past 5-10 years? It might be a young lawyer who only has one or two. That's fine, as long as they're proven that if push comes to shove, they'll go to trial, good enough. If a lawyer says, I don't have any, my advice is look elsewhere.
So if somebody was really just wanted to do some research, where would you point them in terms of finding quality information on the internet, as opposed to maybe some of the potentially misleading information you mentioned earlier?
This is the age of the internet, and every ERISA lawyer I know has a website. And the good ones will be listing their case victories. The good ones will also be providing a huge amount of information about ERISA and how to make a claim. Because to be honest, we don't want people calling us to say, I'm too sick to work, I have cancer, I have MS, I had a stroke, and wanting to pay us. We just would tell them, look at our website, the information is there to help you make your claim. But we also work very hard to keep on our website updated information about new court decisions, new ways to prove your disability. For example, if somebody has long COVID and their primary condition or symptom is fatigue, there is now testing that can prove that somebody has this fatigue, testing that didn't exist 10, 15 years ago. So, there's a term I've heard that doesn't mean a lot to me about being a thought leader. Well, my law firm, we believe, are leaders in the area of ERISA and providing assistance to potential clients who are insureds. So we continually strive to put useful information out there for anybody who wants it.
Are there any particular challenges for claimants in California in a long-term disability policy?
To be honest, I think I would give the opposite answer, in that California is probably the best environment in the country for ERISA claimants. This is in large part due to California's consumer-oriented laws, some of which are adopted by the courts in California. And ERISA cases are decided by federal judges. And for many years, California has had mostly Democratic U.S. senators who are recommending to the president to appoint more consumer-oriented judges. So that is an advantage. It's also, I would point out that somebody who is in California should be looking to hire a California ERISA lawyer because we know the judges and the judges know us. I've actually had private conversations with judges at bar functions and things who've told me that when we see a case come in from your law firm, we recognize it's going to be a credible case, that your firm does fine work and doesn't file frivolous lawsuits, unlike some other lawyers.
I would also imagine that you have as friendly a relationship as you could with opposing counsel that you often see across the way.
That would be true. I'm a believer in you get more flies with honey than vinegar. I am aggressive on behalf of my client, but not aggressive in a way that is going to cause the opposing counsel or the insurance company to be unduly aggravated or find a reason to dislike my client. If they ask for information, we do our best to provide it. We want to give them every reason to approve a claim, not look for more reasons to deny it. If I have a sympathetic client and we're going to go to a mediation, I want to do everything I can to make sure that they see my client for who he or she is, because the claims people who make these final decisions are human and they can be empathetic. So we do what we can to be friendly with our opposing counsel, but of course, never to the detriment of our client.
Some individuals have group policies. How does ERISA apply to group plans? And are there any unique circumstances that one might need to be aware of if they are in a group plan?
Well, first, ERISA applies almost exclusively to group plans. As I think I explained earlier, employers will go out and purchase group plans for their employees. It's one policy and will ensure every employee who works for that employer, whether there's 10 employees or 10,000. Now, sometimes employers will purchase individual policies for their senior executives, and those can be governed by ERISA as well if the employer is paying the premiums, or even if they just arrange it and get a discount for the premiums. It's important for people to know when their claims are not governed by ERISA. ERISA will never govern disability benefits that are provided by a governmental entity, a school teacher, a sanitation worker for the county. Any governmental employee is not going to be governed by ERISA. There is a confusing aspect, though, is that sometimes people are employed by the government, but they get their benefits as a union member. If they get their benefits as a union member or via an employee association that is separate and distinct from the government, those benefits are still governed by ERISA. But it's going to take an ERISA lawyer to tell you whether it is or is not governed by ERISA. The insurance companies are uniformly going to insist it is, even when it's not, because it benefits them, because it provides them so much protection.
So the school teacher, the police officer, I'm just asking this for myself. I'm not sure I understand.
Yes. If they get their coverage through a union, it is governed by ERISA. If the employer directly contracts with an insurance company and purchases a group disability policy and the government entity is the policyholder, then it is governed by ERISA.
So like the police union, like
the police provide long-term disability to its employees, and that is not governed by ERISA. But policemen can purchase additional coverage through like a police protective league. And if the coverage is only provided to police officers and is limited to police officers, that is known as an employee association, and that would be governed by ERISA.
What are some of the potential tax implications of receiving long-term benefits under ERISA? How can individuals best plan to be most fiscally responsible in terms of their tax responsibility?
Well, I like to tell people I don't give tax advice. This is the one area in which I'm comfortable giving it, is that if the premiums are paid by the employee with post-tax dollars, the benefits they receive are not taxable. If the premiums are paid by the employee with pre-tax dollars, so they're deducted from your gross income, or the employer pays their premiums, they are a taxable benefit. The government looks at it as income replacement provided by the employer. Sometimes it's divided up, whereby the employer will pay a percentage, but they give the employee an option to purchase additional coverage and pay for it themselves. If that happens, a portion of the benefit is taxable, a portion is not, and it takes a combination of your ERISA lawyer and a well-schooled accountant to explain the difference.
In your experience, what are some of the more common mistakes that claimants make when pursuing a long-term disability claim?
The most common mistake, I believe, is the insured believes they are disabled and can't understand why the insurance company wouldn't just accept their representations, and they don't fully support their claim. They don't support it by providing an accurate detailing of their job duties and an accurate and supported by medical evidence description of their impairments. Without those two things, the insurance company may find a way to deny the claim.
The ERISA landscape is very much overwhelming for individuals, especially those who are new to it. What resources, educational materials would you recommend somebody who is filing for a ERISA claim, a long-term disability ERISA claim, to pursue?
To be honest, if their claim is so complicated that they're looking for these resources, they should probably be talking to an attorney. I will say that the ERISA litigation landscape can be overwhelming to ERISA lawyers as well. It's a constantly changing landscape. Courts are constantly coming out with new decisions that either support claims or sometimes support insurance company positions. My firm, for the last, I don't know how many years, has been putting out a weekly blog, we call it the ERISA Watch, that gives a summary of every new case, ERISA case decided by the federal courts in the prior week. And we have about 1,500 subscribers, which are lawyers on both the plaintiff side and the defense side who read it weekly, because we think we do a good job of keeping up with the current law. But once again, if an insured has a case that is so complicated that they think they need to do research on the internet, they should probably be talking to an ERISA lawyer. When I was probably not even a teenager yet, a doctor wrote a book called Everything You Wanted to Know About Sex But Were Afraid to Ask. And when I became an ERISA lawyer, after a few years, I decided to create a document that was entitled Everything You Wanted to Know About ERISA But Didn't Know Who to Ask. And it was primarily written for lawyers new to the ERISA field, but it also was often read by insureds who were looking to make claims. We've updated it, we've reproduced it, we've made it more user-friendly for people new to ERISA, including claimants, and it's on our website. It's going to provide the basic answers. It's going to summarize what I've talked about for the last hour in about 3 or 4 pages. It's going to tell you, do I need a lawyer or can I just do this on my own? There's a number of very informative websites. Kantor Kantor's website is very informative. I have a number of colleagues who also have very informative websites. They won't be hard to find. And if you review them and you're still looking for information, as I said, we'll always give somebody a 30-minute consultation to explain their questions and kind of advise them if we think they need a lawyer or not. It's really important to me that people don't hire lawyers when they don't need them. If someone is disabled, they're going to take a pay cut even if their benefits are paid. The last thing they need to be doing is paying a lawyer for no reason. I think lawyers who take on cases just to take them on are, to be honest, unethical, and they are taking advantage of a group of people who need to be protected, not be taken advantage of.
Lastly, for this episode, are there any recent court decisions that, or legal trends related to the ERISA long-term disability space that you think could impact current claimants or future claimants?
There are weekly decisions. There's a saying about there's nothing new under the sun. Well, I'll tell you, in ERISA cases, there often is something new. Something comes up that has never been considered before, and some judge has to consider it for the first time. We're in the process of finding out an answer to a question right now. When COVID started, I talked earlier about you have 180 days to perfect your appeal if an ERISA claim is denied. Well, the Department of Labor suspended that 180-day period and said, we're going to keep that period open because of all the problems with COVID. Well, one insurance company in particular, Unum, continued to tell their insureds when they denied claims, you have 180 days to perfect your appeal, not telling them the Department of Labor had expanded that period to an indefinite time. And we have a client who was so ill that all she could do was write in and say, I appeal. And they denied the appeal. The client came to us and said, can you help me? And we looked at her file and it was deplete of the information she needed. But we also noticed that she was basically at the end of her rope, didn't know what to do. And we noticed that the denial letter gave her 180 days, didn't tell her about the COVID extension. So we are now in court saying, I should back up. We asked Unum and we explained to them, you didn't tell her the truth about how long she had. We want to do a proper appeal to give you the information you need to understand the depth of her impairments. Unum's response was no. We told her she had a right to appeal. She did appeal. If she hadn't, maybe we could have done something for you, but she did, even though her appeal was, I appeal, I'm sick, please pay me. And we think the court is going to say to Unum, you didn't tell her the truth, you can't hold her to that deadline. But this is a question no court has ever dealt with, as far as we know, and we're going to be the first to get an answer.